Good morning, everyone. Welcome to you all here in Cape Town. Thank you for joining us this morning. We're also saying welcome to our audience online from all over South Africa and some people from across Africa and across the world. Thank you for joining us as well. My name is Cheryl Frank. I am a project manager at the Institute for Security Studies in the Justice and Violence Prevention Program. And I welcome you here today to this seminar called NPA Independence, Future-Proofing the NPA. And we're going to have that conversation with our friends and colleagues in the audience here today and with our colleagues online. This is the fifth in a series of workshops that we've been running called the Driving Justice series. And what we've been using this series to talk to our new, we've been using this series to talk to our new representatives in government, actually, and specifically be focusing on key issues in criminal justice, the rule of law, and public safety. And so you may remember that we focused on senior leadership appointments in the criminal justice system earlier on in the year. And we've had other events on public safety, policing issues, and anti-corruption in the past few months. So we're taking as our cue the statement of intent from the Government of National Unity. And I'm going to note some of the items out of the statement, the principles and the commitments made by the GNU, respect for the Constitution, the Bill of Rights in its entirety, a united South Africa and the rule of law, peace, stability, and safe communities, especially for women and children, accountability, transparency, community participation in government. That's why we're all here, community participation, evidence-based policymaking and decision-making. That's also why we're here as researchers and policy people. A professional, merit-based, non-partisan, developmental public service that puts people first, also in the statement. And then integrity, good governance, and accountable leadership. So that's why we're here. And we've mentioned the event we did on senior leadership appointments in the criminal justice system earlier in the year. It's a further issue that we will take forward throughout our work from the ISS. Our panel is here today to discuss an issue that I think has been something that's been on our minds for the last 20 years. It's come up several times, and most recently in the discussions on the NPA Amendment Act late last year. And our friends and colleagues in the room, and I'm pointing to Jean, Redpath, Lucas, have raised these issues in their discussions in Parliament. So we're interested in following up on those discussions now. And we have produced an ISS today in which Martin mapped out some of the key issues. So before we get to that panel, I do have to thank our donors who have allowed us to be here today. So we want to thank the government of the United Kingdom, and then the ISS would also like to thank the members of our partnership forum, the Hans Seidel Foundation, who are here in the room. Thank you. The European Union, the Open Society Foundations, the governments of Denmark, Ireland, the Netherlands, Norway, and Sweden. Just a reminder, everybody, we are live online, so no Chatham House rules. So you will be filmed, as you can see. So just be mindful of that. And I'm going to hand it over to Ferial, our moderator for today. Thank you, Ferial, once again, Associate Editor of the Daily Maverick. And she will introduce our panelists.
Thank you very much.
Thank you very much.
Thank you, Cheryl. Thank you, Cheryl. Delightful to be with you today. I must tell you that as a journalist covering a captured institution, as the NPA was then, was very, very difficult. It was completely opaque. You could get absolutely no answers out of it. And when you went down into the parts that were really important, be it Gauteng, KZN, um, th- the importance of the NPA and its independence was so clear by being able to see its shadow side, or what happens when an institution is part of a state capture project. So it's a vital discussion here on how we future proof the National Prosecuting Authority, and very excited to have a really wonderful and a thoughtful panel here today. The NDPP, thank you very much, Shamila Batoy, for being here, even though I know you're not feeling well, but thank you for making it. Dr. Martin Schunter, thank you for your thoughts and considered concept note to guide this discussion. And then I'm very excited to have Lauren Cohen with us today. Okay, thank you. With us today, administrative law and constitutional law expert, who is very passionate on the topic, as I know. And I'm sorry the last one we didn't get to all your questions, but we will today. So, Ms. Batoy, if I may start with you, when you came back from The Hague, I could almost feel the country heave a sigh of relief, because that someone like you could consider coming home to do this important work. And in considering today, I thought to myself that you would not come back to such a role if your independence wasn't enshrined. And I think you said as much in your public interviews. Subsequently, what has been your experience of not having full independence of this institution so vital to our well being?
No, thanks very much, Ferial. Yeah, you're right. The issue of independence was critical to the decision to come back, because we had seen what happened to the NPA, as you said, captured prior to the current leadership. And so, having institutional independence, having your constitutional independence, so to speak, it's not enough, we realized, because we saw what happened. And so the de jure part of it and the de facto part of it is really important. So when I was first appointed, I've said this before, I met with the president and I said to him, Mr. President, sitting across from me, can you give me your word that you will never interfere in the work of the NPA, obviously inappropriately? And he unhesitatingly gave me his word. Because I said to him, we know, what's happened in the past, even though we have all of these constitutional guarantees. And so that was the first part, really important aspect. And I can say, without fear of any contradiction, that up until today, um, there's been no interference at all in the work from any of the executive members, president, minister, etc. So from that perspective, the NPA has been allowed to operate independently. But there's another aspect to the independence of the prosecuting authority, and that is the functional independence and the able to actually deliver effectively on your mandate. And that covers the other aspect, and that is the aspect where the national director, although, and I talk about the national director because in a conversation like this, it's not about Shamila Batoy, it's not about
Yes.
the current minister, it's about an institution that we all want to, as Cheryl said in her introduction, future proof. Because we're going to be leaving soon and we want to make sure, well, I say soon and the media gets it all wrong. It's 18 months. So I've got to be clear about that. We will leave and there'll be new leadership, and we want to make sure that what we leave behind is an NPA that is future proof. And so one of the other aspects of independence is the ability of a national director to be able to run his or her institution in the way that they want. Can you imagine the CEO of an organization not being able to determine your budget, to determine how you spend it, to determine your certain strategies, to determine your structure? How can you function in that kind of situation? And that is effectively the national director's role, is to function in that environment, because the DG of Justice is the accounting officer of the national director. And if you look at UN guidelines on the role of prosecutors, etc., they all speak about the fact that financial and operational independence is critical. And so I can give a lot of examples in terms of how this relationship has really undermined the leadership of the NPA and has really made it very difficult to make sure that we can effectively implement many of our strategies that we've put in place. So this is a huge challenge for any national director. And I think so how do we actually deal with that aspect? But I do agree that there needs to be, we can further strengthen the
Yes.
NPA's, the independence as far as the legal frameworks, et cetera, is concerned. But I think this aspect, requires really urgent attention.
I'd love if you can spend a few minutes getting under the hood with you. So, say at the beginning of a budgeting cycle, how does it work? What do you have to do to get the money you need to make this machine work? I mean, do you have to get every appointment approved? How long does it take? I'm just trying
Well,
to
firstly,
sketch the parameters of the issue.
firstly, the DG of Justice is meant to even represent the NPA in budget discussions and budget advocacy.
Do you get to go with
And
to those?
we have insisted on it. And a deputy national director who's present here now we've basically forced our way into those conversations.
Forced. So it's
Absolutely. We have had to force our way into those and fight for budget, sometimes without the support that we need. But fortunately, we've been with the Minister of Finance, because we've been engaging directly and really doing our own budget advocacy, as I said, forcing our way in. We've been able to get the budget that we need. But that in itself, to start off with, is a huge problem. And it depends on personalities, unfortunately, who a DG is at a given time, because you have less resistance or more resistance. And so, I'm trying to be diplomatic because I'm also on an open platform.
sure.
But it, things have gotten, well, it's tricky. But so that's to start off with the whole budget advocacy process. And then at the end of the day, the DG of Justice approves a number. Well, we have delegated authority. Let's put it that way. So the DPSA delegations come from the DG to the DPSA appointed persons in the NPA. Now remember, we are NPA appointed persons. That's the national director, all the deputies, as well as the DPPs. But the administrative component that actually report to one of the deputies is actually DPSA appointments. So strictly speaking, we have a deputy DG that actually has a line to the DG. And if you have a DG that is forcing that line, reporting line, they can control the entire administration of the NPA. Although our line is to a deputy national director, but who's not a DPSA appointment, the NPA appointment, does not have the delegated authority from the DG. The delegated authority goes down to an acting DDG.
Is that how corruption of system can happen? Is that how the system can be corrupted or captured?
Well, I think the
our
NPA
work?
can be captured by persons outside of the NPA. And I don't mean captured in a negative way. It could be, it's just that as a national director, you don't have control over your organization. It's impossible to work in that scenario. So,
Thank you. Those are hard words, eh? Difficulty. You don't
it's
have
very
control.
undermining,
It's
actually.
undermining.
You're a constitutional entity, you're required to report to Parliament, but you actually are, have all of these complexities to deal with in what I think was a serious design flaw, years ago when the decision was made to make the DG of Justice the accounting officer for the NPA. You need to have a situation where, for example, like the Commission of SARS is, I think that in the entire anti-corruption family, SIU, etc., the NPA is the only one where the accounting officer is not the head of the institution.
So Ed Kisvetter is
He is the
His
accounting
own,
officer.
he's
That's right.
his own accounting officer. That's the SARS commissioner. Thank you very much for your frankness there. Martin, you've listened to that. You've gone around the world looking at how important prosecutorial independence is for democratic consolidation. Give us some best examples and then tell us what you've heard as Shamila has outlined the problem she has.
No, thank you, Ferial, and also thank you to the ISS for the opportunity to make some inputs. So the world, of course, is a big place, so one has to generalize, but historically, prosecution services were quite the rare breed and the orphans of the criminal justice system. They were either an adjunct to the executive part of the Justice Department, sometimes a part of the judiciary. And in many countries, including in Africa and even in jurisdictions such as in England and Wales, day-to-day prosecutions were done by police officers, not even trained lawyers and prosecutors. That has changed over the last 50 years quite radically. And as part of that change, and especially as countries the first wave was in Latin America, began to democratize, developed transitions away from military rule, from authoritarian rule, then followed by what happened with the dissolution of the Soviet Union in Eastern Europe and in Central Europe, increasing focus was placed on the importance of independent prosecutors, who should not be influenced unduly either by the executive or other interests, organized crime or corporate interest or whatever the case might be. And as a result, in many of these post-transitional countries, as part of the process of democratic consolidation, first in Latin America, Brazil, Argentina, Chile would be examples, then followed by Eastern Europe and the former Soviet Union, constitutional interventions were put in place which protected the prosecution service from executive interference, mainly in two ways. First, the one way was to create an independent, autonomous institution who had, and this is relevant, I think, to the debate here in South Africa, which had control over its own budget, it had control over human resource decisions, and could determine its own strategy about what it wanted to do. The other important innovation or intervention was around the appointment process of the most senior prosecutors in those prosecution services. That wasn't overly in the hand of just one person in the executive. In South Africa, the presidency has an unusual amount of control, but that these processes were done in a more open, transparent, and deliberative way by a group of experts who engage in the appointment process of certainly the senior leadership. One other important development, which I think is worthwhile mentioning, given the relevance to South Africa, is that with the dissolution of the end of the Cold War, there was an increasing awareness of organized crime and corruption and grand corruption around the world. And a lot of policymakers, both in domestic jurisdictions and internationally, realized that to properly be able to combat corruption, an independent prosecution service was no longer a luxury, it was vital. And soft law developed, and even international treaties, the UN, United Nations Convention Against Corruption, which South Africa ratified almost 20 years ago, are quite explicit that there's a need for an independent prosecutorial entity that can engage in anti-corruption work, that does have control over its own finances, its own budgets, important human resource related decisions. And I think that's quite relevant to the South African debate as well.
So in Brazil, for example, it's President again, Lula, he went to jail. Is Brazil a good example to look at of properly enshrined independence of its prosecutorial service? Or I'm just looking for examples.
Yes, I mean, in some ways it is, but there's also been backsliding. So there's a lot of concern now. There's sort of been a resurgence of authoritarianism, of the politicization of criminal justice systems, including in Brazil. So no system is perfect and completely resilient to political interference, especially when it comes to grand corruption. Of course, it's important to put in as many checks and balances and protections as possible into the system. But it's not a guarantee. At the end of the day, one needs, or these prosecution services need an independent media, a vigilant civil society to make sure that if there is undue interference, that the public becomes aware of it and speaks up, as it were. There was, if I may just add, there was an interesting multi-country study looking at both sort of legal independence and practical independence of prosecution services. And it was more the latter, the kind of practical independence, which was more important to protect prosecution services in the anti-corruption sphere. And that has to do with
Really interesting.
civil
So we
society
have
voices.
the constitutional, but not the practical.
Exactly.
Okay.
So both are important. I think South Africa has done quite well on the kind of the legal side. There's still some tweaks and necessary amendments that need to be done to the law, but constitutionally and on the face of it, the NPA is independent when it comes to prosecutorial decisions, although historically there have been interferences there as well. But I think the main debate now, as the NDPP has said, is around the operational and financial independence. And I think there needs to be a discussion as to how the most senior leaders of the NPA are appointed.
Thank you very much. Lawrence, so what are you scribbling there?
I think better when I write.
That's lovely.
I don't know,
So
it's
you've
old school, sorry.
written, so we've chatted because I think we both saw how the state, its systems, our future was disemboweled by grand corruption. And I think we're still counting the
Every
cost
page
of that every day.
Zondo report I've read, hey, all 5,000.
So you're passionate about something you call the fourth branch of the state.
Yeah.
Tell us about that.
Okay, so you're jumping to my question 3. I can tell you about that. It struck me, in fact, many years ago when I was in practice at the time at Weber's, and I read the Constitution cover to cover, and I realized that insofar as we hold fast to this Trinitarian notion of the separation of powers, that state authority is divided purely between legislature, executive, and judiciary, that is a falsity, right? If you read the Constitution carefully, and I say Constitution big C and small c, so constitutional court jurisprudence, insofar as it gives meaning to the Constitution, what you recognize is that there are bodies that fall outside of those four loci of state authority, but which nonetheless exercise very important and distinctive public powers in the public interest. And these are not powers that are mere administrative action. So this was, for me, everyone's sort of now talking about the fourth branch. The inclination in academic literature has been that South Africa set the blueprint with our Chapter 9 of our Constitution. And we've got these wonderful institutions like the Public Protector and the Human Rights Commission and so on. But it struck me that that is an oversimplification, because where do you locate the NPA? As Shamila's rightly said, as Martin has rightly said, de jure, these bodies are constitutionally enshrined as independent. Constitutional Court has reiterated the independence from a de jure perspective of the NPA repeatedly. And it says as much in the Constitution that they must act without fear, favor, or prejudice in respect of all these bodies, the JSC, the Financial and Fiscal Commission, the Public Service Commission. They must all undertake oaths of office. So I started recognizing that there's a pattern here, that these bodies are their functions, and the various courts have confirmed this, that decisions of the NPA to prosecute, not to prosecute, are not administrative action, right? So that says something about the status of the institution, its role within our system, within our state system, and equally about the nature of the powers that it exercises. And it struck me that it is, you see, this sort of this throwaway line of ministerial responsibility, and I know, Paul Hoffman, it's a gripe of yours, and it's rightfully a gripe, because you've all spoken about independence. You've spoken about structural and operational independence. But equally, there's the importance of public perceptions of independence, right, which go to that. And we need to be mindful, just as we need to be mindful of the judiciary's authority, we need to be mindful of the NPA's, right, as members of the public in constructive dialogue on it. And we need to recognize that it's decisions to prosecute and or not prosecute, like those of the legislature, like those of the judiciary, like those of the executive, are not subject to administrative action review under the PAJA. So that is indicative of their special status. And so I therefore theorized this unifying framework, which works within South Africa. It may not work elsewhere, for what I call the integrity and accountability branch of state, but it's in relation to public integrity and accountability. And I think the NPA, as you know, Martin's pointed out, in foreign jurisdictions, there's an inclination, for example, in the Netherlands, you correct me if I'm wrong, they sort of see it as part of the judiciary, right? In other jurisdictions, it's seen as an executive adjunct. in my view, the Constitution is very clear. It's in the chapter on the courts and the administration of justice. You know, it's not in the chapter on the executive. And I've read the entire NPA Act, and I've read all the regulations, and I've read the Code of Conduct, and your mission statement, and your values, and every case. And on the face of it, de jure, absolutely, there is a requirement that it be structurally independent. There is a requirement that it be operationally independent. And if you read the case law,
What does Glenister say?
Well,
and others.
Okay, Glenister. That Glenister 2, hey?
Everybody knows the Glenister judgment.
Glenister 2. No. Paul's written a whole book on Glenister, okay, under the swinging arch. Now, in my view, these are the takeaway points from Glenister 2. Bob Glenister was a businessman in Johannesburg who saw the writing on the wall in regard to corruption. And this is where the courts, in fact, have, in many ways, stepped into the democratic breach, right? And I've looked at the judgment afresh now through a new lens. And in fact, I think what Cameron does there is quite a reach. He essentially reads in a structural requirement into the Constitution that there be created independent oversight mechanisms, the term mechanisms is used, based on, amongst others, international law. You've mentioned the UNCAC, as well as Section 7.2 of our Constitution. The state must respect, protect, promote, and fulfill the rights in the Bill of Rights, as well as the heart of the Constitution. And pursuant to this amalgam from the very heartbeat, okay? And we love the outcome. We love the outcome, yes. But doctrinally, it's a little bit dubious. Now it's been rebooted and reloaded in recent case law. And essentially what Glenister did was said that the state has a positive obligation, and the actual words used, if I may quote, because I like to be technically correct, the state has an obligation to create adequate, efficient, institutional and legal mechanisms to prevent undue political interference in order to combat the scourge that is corruption. Okay? So it started with adequacy, and it referred to both institutional and legal mechanisms. That also speaks to some of what you say in relation to functionality, right? It's not just about what the law says, it's about how do we enhance the functionality on a day-to-day basis. And then, of course, there was reference to the OECD. And I know Paul Hoffman refers to them as the STIRS requirements, which emerge from the OECD report, which is that you need specialization, you need training, you need resources. This is all true. But our court itself, at the end of the day, discerned its own test for independence. And it said, in short, that we need structural independence and we need operational independence. And insofar as those two things, and then there needs to be a public perception by the reasonable objective person. So if the reasonable objective person in the public has reason to believe that the NPA is not sufficiently adequately independent, that's also problematic. And then the court articulated certain factors, and these include, for example, remuneration, security of tenure, the oath of office, mechanisms for accountability and oversight itself, okay, appointment. Now, I think the biggest flaw, which has already been alluded to, and my brief was this is salon style, so I'm going to springboard, okay, is that...
But can you springboard quickly?
Can I springboard quickly?
Yes, thank you.
The springboard was, now I've lost my springboard, but
Sorry.
but the point was the appointment of the NDPP. In all of these judgments, Ferial, the court likens the Chapter 9s, the judiciary, to the NPA. So in other words, it is perceived as requiring the same degree of independence, okay? But the difference, if we look at how our Chapter 9s are appointed, if we look at how our judiciary is appointed, it is problematic that there is so much power in the hands of one leader to appoint the NDPP, because the NDPP is like akin to the Chief Justice. And I think we need something similar to the JSC to see to sort of the appointments of the NDPP.
Thank you very much. So, Ms. Batoy, it was Dikgang Moseneke who said that we had made a constitution for Nelson Mandela. And in fact, you need to make it blind of a veil of ignorance, I think, should apply as you create institutions. How did you experience your appointment process? I know the president, out of goodwill, opened it up, made it a public process.
I think, the point that's made about the appointments is is critical, and it doesn't just stop about at appointments. It also goes to how you vacate office, and if there's any inquiries and things like that. So it's all linked, and it doesn't just stop at the NDPP, because in the NPA the top 3 levels are presidential appointments. So it's a national director, it's a deputy national directors, and it's the directors of public prosecutions in each province that head up the NPA. And then it goes further in terms of executive involvement in appointments, because the next level, which is deputy directors of public prosecutions and chief prosecutors, the minister makes those appointments.
Wow.
So there's a lot of executive.
So do you submit names and the minister chooses? Or just
In fact,
technically how
it's a
does it
bit
work?
crazy at the moment, because we even have to write to the minister to get her to approve us to advertise the position,
No.
Oh, really?
and then to approve the panel. And then and I've been writing to
So
ministers.
every time.
I've been writing to ministers to say,
Sure.
can you please delegate that to the national director so that we can move with these processes a little quicker?
But how
So
does
hopefully-
that suck up your time? It should be about strategizing.
I think you can all imagine
Yes.
how, it's, and we have a very competent HR capacity in the NPA that can do all of this. It does a lot of it.
Yeah.
But it's just approval that needs to go. So right from the point of advertising, panel approval, appointments, approvals. So so I was saying there's these 4 layers, so when you start, I deposed to an affidavit on behalf of the NPA during the Zondo Commission, when at the request of the Chief Justice at the time, Chief Justice Zondo, on the issue of the independence of the NPA. And this issue is dealt with at length there, where we basically say that you asked me how my appointment process. I think that was an excellent process. And we say in the affidavit that there should be, maybe it should be legislated. Of course, if you want to take away we do say that, for so much of authority to vest in one person in the president, to appoint a national director can be problematic. And we say that there should be amendments to legislation. Maybe, if you want to take that, look, in lots of countries, as Martin said, the presidents do appoint these heads of these institutions. So it's not unusual, but maybe you need some safeguards, like legislating a particular process, maybe in the NPA Act, that still gives the president the ultimate decision. But, as we've had case law that says it's got to be a rational, objective decision. It's not just the president thinks this person and so.
That's how it used to work.
Well,
at Capture.
precisely. So we need to actually factor in these safeguards to ensure that, the president still can appoint, but there's all of these safeguards built in. And I think the process to appoint the current national director was a really good one. And we support, and in the affidavit, we propose that this is something that should be done. But we don't think it should be akin to the JSC, because that we think is seriously problematic.
So in what sense?
Of the politicians that are involved in that process.
Okay.
But for example, those that were part of the panel when I was appointed were heads of various legal bodies. And I think that might be something to consider. But so, I think the appointment, and as I say, it goes right down to and we propose in the affidavit that the first 3 levels, you can look at, some kind of process like the national director for all levels. And for the 4th level, the national director should be able to appoint. If you get all that right, surely the national director should be able to approve at the next level, at least.
Thank you. I didn't know it was that deep, that you
I
had to
agree
seek
with that.
approval of everything. Martin, can I ask you the elephant in the room question? And you can say if you're not comfortable, because I think the moment provides us with a perfect context to be having this discussion. We have a justice minister who faces really serious accusations of being in receipt of VBS monies. And my colleagues, Polly Van Wyk and Kyle Cowan, I think, are unpicking that in quite a forensic fashion. And yet, that same Justice Minister makes every key we can hear decision about the NPA. Is it a perfect example of why we need more enshrined prosecutorial independence?
I mean, it's certainly potentially a good example. I mean, I don't want to prejudge the actual scandal here in South Africa. I haven't been following it closely enough. But I mean, at the very least, it must be a tremendous distraction for the minister. So not to be able to apply her mind to what are, it seems, often fairly mundane decisions that the NPA wants to make to operate effectively. So I do see the crisis as potentially an opportunity to make the argument that for these kinds of human resource and operational decisions, it should be decisions which the NPA should be able to make internally. It's in a way just a good governance thing. Otherwise one duplicates so many things. But it's also a good way to future-proof the NPA, which is a theme of this discussion. So if I may just add on to what the NTPP said about the appointment process of the most senior positions. So that is increasingly an internationally a good practice, is that one creates a fairly diverse panel who assists in the selection process. And that would be, it would include members of the executive, typically the Justice Minister, but it would also include representatives of the legal profession, of academia, importantly of civil society, and possibly other important interest groups.
And they do a short list.
And so there would be a public call for applications, and that's very widely advertised, so many people can ideally apply. And they would then do a short list. And those shortlisted individuals are then, the names are revealed, and the public can actually publicly comment on those individuals, positively or negatively, about their previous experiences with them, how they dealt with a case, if they're lawyers, for example. And that all becomes part of the body of information that is then used in the actual public interviews of the shortlisted candidates. And what that panel would do is they would then create another shortlist of maybe 3 selected persons, maybe 5, and the president makes a final decision amongst those 3 or 5. So the president's decision is still important, but it's informed by public participation, input, and a shortlist which is given to the president by this panel.
And it's owned publicly, so there's real contribution. Thank you very much. We have a great room here, so I'm going to open for questions. Please let's play ping pong, not cricket, if okay with you. And you can ask any of the panelists. I'll also look online, where I think we must have quite a few questions by now. Please, you're welcome. I see so many.
Ferial, am I allowed to just comment on what my colleagues have just said in the spirit of salon-style discussion?
Salon-style, go
yes,
for it.
okay. So at the outset, you mentioned the vitality of the role of the NPA in the context of deepening democracy and in strengthening the rule of law. And that goes even back a step further. What is the purpose of the state? The purpose of the state is to advance the public interest. The NPA has a crucial role in that regard, right? It has to prosecute crimes in the public interest, okay? I think for me, 3 themes have come through here. Number 1 is a collaborative stakeholder, multi-stakeholder endeavor, and the value of expertise across the board. And number 2, what our NDPP alluded to, the value of integral leadership, that we need strong leaders at the top because so much filters down based on that.
Thank you.
I don't know if there are questions
I'm sure
that
there'll
flow
be
from
many.
that, but
There are a couple of mics going around, so we'd love to hear your questions or comments or thoughts. Huh? 1, 2, Paul, welcome. Please introduce yourselves.
can you not comment? Can you stay a bit
Am I first up?
You up.
I think,
please?
is the mic on?
Yes.
Yes, it is. Thank you, Ferial.
Okay.
I'm Paul Hoffman from Accountability Now, and I have a question for the entire panel. Section 179 of the Constitution, and I'm sure Lauren can give us the exact wording, calls on the legislature to pass legislation that ensures that the NPA can work without fear, favor, or prejudice. I don't know of such legislation. Perhaps somebody can help me on the panel, because as far as I can see, the final responsibility that the minister has over the National Prosecuting Authority, the concurrence in its policy that the minister must provide, and as the NDPP has very correctly pointed out, the fact that the accounting officer of the NPA is a person who's not even part of the NPA. It's the DG of Justice. How do we ever get to a constitution which accepts that the NPA is an independent body when we have all of these hurdles in the way?
Thank you very much, Paul. And let's take a second question.
Good afternoon, everyone. My name is Ruben Klopper. I'm a UCT law student. And my question goes to Professor Khan. Regarding the practical protections that can be put in place, do you think that bringing the decision to appoint an NDPP or those top 3 levels of the NPA within the scope of review under the PAJA could provide those protections, or would that be an overreach?
My sense, you see, those decisions would be analogous to decisions pertaining to the appointment, on my fourth branch theory, pertaining to appointment of the Chief Justice, the public protector, and so on and so forth. So I don't think those appointments would be administrative action, but equally, as Advocate Pretoria has alluded to, that those appointments would need to be rational and therefore meet the requirements of legality. And you cannot obviously appoint someone that is not fit for purpose, right? So that cannot act without fear, favor, and prejudice. I actually just reread the Corruption Watch judgment regarding Sean Abrams, and you'll all recall that Mr. Ngasana was put, Sean was put there because Mr. Ngasana was not a lackey, okay, let's just say, and didn't toe the party line. And then ultimately, essentially took a bribe because he was carrot, stick, carrot, stick, carrot, stick. And then, poor guy, he was threatened with his reputation. So he left. And in this judgment, Madlanga says, at the end of the day, you cannot put someone there, right? And we know this from Similani. We know this, that the NDPP has got to be a person of absolute integrity. And if you're lying under oath before a commission of inquiry, you're clearly not a person of utmost integrity. But it was very clever because there they used the Odecrawl rule to get Sean out. And because in other words, insofar as Mr. Ngasana's dismissal was unlawful, subsequent appointment of Sean Abrams was therefore invalid. And they could exercise their remedial discretion such that in the interest, and this is what they said, the NPA is so important that we need stability, we need trust, we need faith in the legitimacy of the NPA, that we're not going to apply this retrospectively, that Mr. Ngasana must go back into office. So to answer your question, I think there would not be administrative action, but there would be subject to legality review, which we know is becoming increasingly searching. And to answer Paul's question, and maybe someone else on the panel, I don't know, Ferial, if you want to direct someone else, but I mean, Paul,
I'd like each of you to have a go.
Yeah, I mean, I do think this line, I mean, and I think the accounting officer question, it's a valid one, right? When I read the suite of legislation with the jurisprudence, I felt that overall it painted a picture of intended independence as per the de jure requirements set out in the Constitution. It's not to say we don't need reform. I think that this line of final ministerial responsibility is misleading, and I think it is potentially damaging, and it certainly undermines the public perception of its independence, and I think that that should be removed from the Constitution. I think that our NDPP suggestion regarding levels of appointment makes absolute sense. And Martin, your point about in comparative jurisdictions, that there's some legitimacy to the appointment by virtue of a degree of political involvement, but that's mediated by the involvement of academics, lawyers, civil society, etc. So it's about striking that balance and then giving them the autonomy at the fourth layer to get on with things. Because people forget, we also need an efficient and effective state. We need institutions to be able to act expeditiously in the public interest and not be hamstrung perpetually by bureaucracy and red tape. And part of the problem here is that this is effectively rendering the institution ineffective, like functionally. So it defeats the very purpose.
I think it's what you've achieved, given the strictures you face.
Yeah, it's
Pretoria has
unbelievable,
been
actually.
phenomenal. because
Can you
I
repeat that, please?
Yes,
Yeah,
of
I asked her,
I
can
mean,
she not get her to
I
stay?
say this often, so we'll talk about the Zapiro cartoon later. But
Well, you seem to be
but
sleeping.
as somebody who covered that very opaque NPA out of which it was impossible to get any
Yes.
information nowadays, and if you can, you should be on the NPA WhatsApp group because there are some fundamental and longitudinal changes taking place, especially in the prosecution of sexual violence crimes that I don't think we've properly even begun to understand. So that you managed to get thus far is quite amazing. I want to ask to bring you in on Paul's question, how does final responsibility impact your work day to day?
Yeah,
So
very
the-
good question.
no, this is something we also dealt with in our submissions to the Zondo Commission. And look, the legal framework gives some guidance in terms of what that final responsibility should be. And it relates to policy issues, it relates to policy directives. The minister can request reports, can also request reasons for decisions. And so there's some level of guidance that's given. You know, I'm really
That's how I read
pleased
it.
to say that you know, working with, you know, in my entire term, we've never had a situation where the minister has actually done anything that caused us to become in any kind of conflict because of this. But look, we know that in the past, there have been NDPPs and ministers that have clashed over this. So, you know, it's going to be a tricky one because, you know, as Martin said, it's, I think most Commonwealth jurisdictions certainly have some level of connection to the executive. So we propose in our submissions to Zondo that this, not that it be removed, but that it be perhaps clarified and, you know, more kind of certainty given to very clear delineate what this actually means. Because it certainly doesn't say that an NDPP is accountable to a minister.
Exactly.
The NPA is accountable to Parliament, and that means the people is not accountable to the minister, but there is a responsibility that the Constitution and the legislative framework gives. So practically, that for us has never been a challenge in the current context.
That's good to hear. So I read the Sunday World quite regularly. I don't know if any of you do. Florencia's laughing there. But anyway, it's if you want to understand what the populist wing of politics is doing, so read Sunday World. So in there, I read a lot about how the Justice Minister or Department told the NPA where to get off on appointments, on the data, on the Zondo database, etc., etc. How do we prevent that kind of political interference or the instinct toward political interference? What does the best case look like, Martin? And to also take in Paul's question.
Yeah,
please.
I'll address Paul's concern as well. So I think your opening comment, Ferial, at the beginning was right. I think when the Constitution was drafted, and even when the NPA Act was drafted and promulgated, it was done in the context of a very benign executive. So it gave a disproportionate power to the executive and executive bodies. We know now that that was naive in retrospect. Things changed quite radically thereafter. And I think that kind of awareness is very important, and that's certainly not unique to South Africa. We see that in many jurisdictions, how extraordinarily difficult it is for prosecution services to successfully prosecute previous heads of state, not even to speak of sitting heads of state. It's actually quite rare. The NPA stands out that it's been so tenacious, certainly under the present leadership, to pursue the case against a previous president who is still a powerful political figure. That always brings with it a lot of interference. And I think to the extent that one can limit that legislatively, it's crucially important. So that's either removing that final responsibility section or clarifying it and circumscribing it, limiting it in legislation. It's not foolproof because a simple majority in Parliament can change it, but it's less arbitrary than the minister just waking up in the morning and sort of deciding what that final responsibility might mean. And it's the same with the operational independence, the issues that the NDPP spoke about today. I mean, in practice, and this has happened in the past, the DG can delegate many of these human resource and financial decisions to the NPA. And in a perfect world, that has worked fine. But I think you want legislation and safeguards which anticipate worst case scenario. One has to be a cynic, because the prosecution service is so powerful and so influential. It'll always be under tremendous pressure from a whole range of stakeholders not to fulfill its constitutional mandate. And that's the same in South Africa.
Possibly, why would a DG want to hold so much power and not delegate it? I know I'm not trying to put you into the head of this DG, but what's the political instinct? It's power. It's
well, I think
many
that's a normal universal instinct, especially for people in executive positions, certainly for politicians. Power is always very appealing and addictive, and it's always difficult to relinquish and give away once you have it. Because once it's given away, then it's always a bit more difficult to claw back as well. So I think instinctively, people in positions of power don't want to give it away. I mean, but there is also, and I'm not saying that this is the case in the present administration, and certainly that's not the impression the NDPP has given us. It is certainly a tool, quite a legal tool, which can be used to slow things down, to disrupt things. It's not a tool to interfere in individual cases, but it can make life quite difficult for prosecution service to function effectively. And I think that's an important point to make. This isn't really only or all about the NPA's work on anti-corruption, as important as that is. But South Africa is plagued by at least two things: very high levels of corruption, both historically and even now. But in addition to that, also very high levels of general crime, sexual offenses, violent crime, and so forth. And the sort of the ratio of prosecutors to reported crime is actually very low in South Africa because of high levels of insecurity. So any impediment to the NPA's operational effectiveness is very unfortunate, given the level of insecurity in the country.
Thank you very much. Thank you. Any more questions in the room? Yes, please, before I go, Nikki, first there and then Nikki.
Thank you. And my name is Lucas Minting. I'm at the Dada Omar Institute at the University of the Western Cape. Thank you to the ISS for this opportunity. We think of the prosecution's work as essentially being to prosecute. But a very important component of the prosecution's work is not to prosecute. In other words, to make the decision to decline a prosecution. And I think we need to look at that part of the work more closely. The decision to prosecute is reviewed by a court. That's just normal procedure. But the decision not to prosecute essentially happens in secret. So my question is, how can we make that process more transparent and make the prosecution service more accountable, especially if there's reason to believe that declining to prosecution is taking on systemic proportions that are not to the benefit of the public? Thank you.
Thank you. Great question, especially with the decision not to prosecute Pala. Shamila, would you like to have a go at that?
Oh, sorry, is that for me? Yeah, so look, it's not taken in secret, these decisions. I mean, if a complainant wants reasons, we have to give reasons for our decisions. I remember the good old days of prosecutions, probably 35 years, when we just said, that's my decision, take it or leave it. It's not like that anymore, and for good reason. I'm being facetious there. So we have to provide reasons for decisions when we, and if cases are withdrawn, prosecutors, as a matter of practice, they are required to call in a complainant and explain why the charges are being withdrawn. It's really important. So we communicate at the lowest level. And of course, if there are more, I mean, we often get queries, requests from complainants asking us a whole lot of things about progress in cases, why things are not moving as fast as they should. And we are required, to the extent that we can, without compromising an ongoing investigation, we can give a level of some kind of information. But the idea that we decline to prosecute in secret is completely factually incorrect. I think I'm not sure if
Can I add?
yeah, sure. I'm not sure if I'm missing any part of it, but of the
Would you like to tackle?
No.
Maybe just to add to that, because Lucas raises a very important point that the flip side of independence in a way is accountability. And both of those values need to work in tangent and complement one another. I've studied a number of jurisdictions around the world where the drive towards independence became so acute that at the end of the day, the prosecution service was no longer accountable to anybody. And that's also not what we want to add up on, because then a rogue prosecutor gets into that position, that senior position, and is undismissible. That's not the case in South Africa, but I think we shouldn't lose sight of that either. And the NPA has done a lot of work and made strides in that regard. It's setting up, I believe, an Office for Ethics and Accountability, sort of internally to police itself. It obviously reports a lot to Parliament. And then it's doing some innovative work around community prosecutions, where in high crime areas, prosecutors engage with much more closely with community members, community leaders, and listen to the community about what kinds of crimes and forms of criminality should be prioritized in that district of the country. And that's also an important form of accountability. It's not always accountability up towards the executive and the minister. That is important, but it's also one has to be accountable in a democracy to the people. And that goes to Lauren's point early on, that it's about perceptions as well. It's not just what's in the law, in the constitution, but how people perceive the prosecuting authority to be.
Thank you. I can ask to any of you, I feel like that culture of justification has been lost, especially with regards to deferred prosecution agreements. I know they're called something different I can understand when I read your work why they're an important method, but I feel as somebody sitting on the outside, it just looks like rich people can buy their own justice. So I feel like that culture of justification wasn't clear.
I think it's important that we deal with that, because that is a perception out there, and it's a totally incorrect perception, because, and we have been at pains to try to explain, maybe we just haven't done enough in terms of how these, we call it corporate alternate dispute resolution mechanisms function. And this is something that is an international good practice. The OECD actually fully supports it. We develop guidelines working very closely with the OECD and looking at researching it very carefully. And so it's very important to understand that corporate alternate dispute resolution mechanisms relates to the company, the juristic entity, not the directors, not the individuals. So it's important to understand that this resolution between a company and the prosecuting authority is that the company will be absolved on certain conditions. It's conditional.
Has to pay back.
It's very important. That's one of them. And it's a whole lot of other conditions. Could be in the negotiation phase, you could put in a whole range of conditions, which could also mean the company could be charged at a later stage if they don't comply with those conditions. But importantly, the directors are not absolved. And so very often, in fact, not always, one of the conditions is that the company actually works with law enforcement and helps us get evidence against the delinquent directors. And so it's not about rich people being able to get away, because firstly, it's not an agreement with the people do not get any kind, there's no agreement that you will not be prosecuted as an individual. But the important thing is that the billions that you recover in these processes for the country.
Do you get to keep those billions?
Unfortunately, no. But no, the billions, part of it, some of it goes into CARA, which if me as a member of law enforcement, some of it goes back into law enforcement. So yes, a lot of it goes to the victims and complainants. Eskom got paid a lot of money from one of the settlements, agreements that we reached. So it's money that goes back into rebuilding the country, money that we need, and it's billions. So, we're looking at also working with, some NGOs in terms of how do we make sure that the companies pay what they should be. There's some way of calculating the damage. So it's a really important tool in the toolbox of accountability to ensure that corporates, not individual, corporates are held accountable.
Thank you.
Can
I
I
mean, I
add
don't
something?
want you to answer
Yeah.
this, but just because I do want to move on. But it really pains me that the McKinsey guy who did all the corrupt rubbish here, and it was a lot, he's just gone and started a fancy startup in the UK. The law is so far from touching him. And there's many examples like that. So this is why my concern about these agreements. But I hear
The
it
hand of the law is long
explain.
sometimes,
I
very
hope so.
often, but
Ferial, can I assuage your concern
Quickly, though.
somewhat? Yeah, I know.
Sorry,
but
sorry,
You
Lauren.
talk about a culture of justification. I mean, the actual policy document itself, Corporate Alternative Dispute Resolution, it's got an entire provision on transparency. So all alternative dispute resolutions are recorded in writing. A summary is published on the NPA's website to ensure transparency and accountability. So I don't think, and I think that they're very clear criteria. I don't think it's like the secretive little, like, you know,
Thank you.
backsided settlement. Yeah.
Thank you very much. It's also because we have so few journalists covering the criminal justice system that perhaps we're not doing it justice. Nikki, please.
Nikki Prince, I'm former head of research from the State Capture Commission. So the NPA often gets judged by the public, by the prosecutions that have or haven't taken place and how long it's taken. So to what extent, if for the last 6 years it had its full functional independence, you know, the financial and human resources, how much further do you feel it would have been in its prosecutions, especially the big ones that the country expects, and included in that, you know, its ability to have rebuilt its capacity and reform its structures and so on. So just a sense of how far you think it could have come if it had that.
Thank you very much, Nikki.
that's an excellent question,
It's
but
really
very hard to answer. But let me say that when I was appointed, I had the view that, you know, how difficult can this be? One conviction will turn sentiment around. And that can't be hard. I mean, this was going to be terribly easy. So how wrong was I? And so in addition to all of the issues you raised about, you know, the independence operation, access to Zondo Commission, a whole lot of things, you must remember that after the national director was appointed, it was 18 months that nothing else changed in the NPA except a national director. Not even the senior leaders. I walk into that. Can you imagine the CEO coming in without your team? All you do is a CEO on the top. You've got everybody still in place. How do you even begin for 18 months to try to run an organization like that? It was only in June of 2020 when 2 deputies were appointed. And the first year, you're trying to understand, you're trying to speak to deputies that are there, you know, you want to change leadership. There's not much that's happening. So 2020 June, we had 2 deputies appointed in the middle of COVID. So in addition to all of the challenges you're talking about, in the middle of COVID, and it's only in March of 2021 that we actually, coming out of COVID, the 3rd deputy was appointed. And we could really start now. I had the full leadership in place, 2021 March. Out of COVID, let's now really start turning the ship around that was captured. That's when it started. And now we're 3.5 years away from there. And so that's the point when, in addition to, well, we had the leadership in place, your question about, you know, we know when you have a really good investigation, when you have all the capacities and capabilities, Martin will tell you, and we've said this, even in very well-resourced global jurisdictions, it still takes a while before these cases come to court. So I think it would have been a lot easier, but I don't know how much quicker. If you take, for example, Steinhoff, the Germans prosecute, the indictment was served 5 years after they started investigating. In South Africa, it was 6 years. So we were 1 year more than the Germans. One would have expected that we would have been twice as long because of all the challenges that we face. If you compare it with a well-resourced country like Germany. But we came in 1 year. And of course, as one of my colleagues said, you know, Jooste chose to be tried in another jurisdiction. But, you know, the matter was, you know, ready for trial. And there's been two. So these things take a while, but I can only imagine with what we have actually achieved in this short space of time, 3.5 years. In terms, I mean, the Transnet matter was in court just this week, one of the Transnet matters. And if you look at all of the accused that are in this, that was a locomotive case. There's Brian Molefe, Anoj Singh, Gama, Gary Pita, Romus Bodhi, Regiment's Capital Directors, Neven Pillay, Nahonia, Trillion Asset Management Director, Daniel Roy, Kuben Mudli, Albertine. There's top state capture people that are in this case that's in court at the moment. This is one case. There's the ID, we've mentioned how many cases that they've enrolled. The asset forfeiture, we've actually, and you know, it's terrible because when I say this, it's like blowing your own trumpet, you know, but it's very awkward. So the asset forfeiture, the recoveries, the billions that they recover, the Optimum coal mine that the AFU seized, that was on the basis of Zondo Commission work, really, purely. And we were assisted, you know, supported by Matthew Shaskelson very much in that matter. We seized a mine the size of Singapore, which is one of the biggest assets owned by the Gupta-linked group. And that is a huge, huge, you know, achievement on the part of the AFU. And so we're moving with chapter 6. We are looking at, that is chapter 6 for people that don't know, it's non-conviction based forfeiture, because we know conviction based cases take a long time. Even when we get these cases to court, and I've got the figures, the numbers that the ID has actually enrolled. You know, Glynis Breitenbach was saying in Parliament, give us one conviction, just one conviction. And maybe then she might change that and say that we're not just talking the talk, we're walking the walk as well. But I guarantee you, when there's one conviction, they'll be saying, you guys just got one conviction? You know, it's never going to end, but we need to move towards that one conviction. And the challenge is, we've said, with people that are charged with these high-profile corruption cases, they are well-resourced, they have deep pockets, and they will Stalingrad us to death. And unfortunately, our legal system, I think, is not being hard enough on complete abuse of process, of court processes. And we need, rule of law doesn't mean you enroll. It means that the system works and that the case is taken to finality. And so we have got a lot of, you know, we're putting a lot of effort into prosecutors being able to fight these, including getting Section 38 counsel from outside to fight these cases in court so that we can get the cases moving. And then we get criticized for doing that, you know? So it's very difficult. So we really, you know, maybe the judiciary needs to be stronger. There needs to be harder case management so that cases can move through the courts quicker. But so I hope I've answered your question, but yeah.
Anton?
Don't ask a hard question, Anton, please.
No, thanks a lot. I was just going to say, I don't know who your colleague is who made the comment on US's jurisdiction. He's a very witty guy.
Definitely was.
So this is very useful. Thanks, colleagues. I think that was a great overview of the issues, but I don't want us to, I know the focus of this seminar is on the independence question, but I think we've heard a lot about design flaws and challenges that have been introduced into the legislation and the prosecution approach. And I think we shouldn't lose sight of those as we have this discussion on what reform is needed. The NPA is under attack. The rule of law remains incredibly precarious in this country.
More on that.
I could. And it's a very important point because I think as civil society and as those of us that really care about accountability, this is a dangerous time. It's a dangerous time. We need to choose our criticisms carefully. We need to choose our responses carefully. We've said it, NDP and I wrote an op-ed saying the last thing we need is a complacent country. We need to be held to the highest levels of scrutiny. But I think we need to be aware that when the system was created that we're operating in now, it wasn't only this euphoric moment of Nelson Mandela that was perceived to be a saint at the time.
Mm.
But we're also a very young and inexperienced democracy. So we made some mistakes in how we drafted the law and the constitution. There's been jurisprudence since then that has guided us. But those design flaws have never really been fixed. But we shouldn't forget that there was a second level of design flaws. The first one were inadvertent. Just because we were in this great moment and we didn't really know what was going on. So we passed the NPA Act that had some problems with it. But the second introduction of flaws was very, very intentional. State capture was a very intentional dismantling, not only of the capacity and morale of institutions, it inculcated a culture of fear across organizations, which unfortunately is creeping back in. That culture of fear incapacitates organizations that are meant to act independently. We must be very careful of that. And I speak as someone who has to work with 3,500 prosecutors that are increasingly fearful. But those flaws that were brought back into the system haven't been dealt with yet. And we have to start looking at a number of them holistically. Of course, one of the big ones we've been fighting for a long time, and I know Paul has a different view on us, but that's bringing back prosecution-led investigations. It's a vitally important step. You can't fight corruption cases without a prosecution-led model, and we've come a long way on that, but only a month and a half ago was the law promulgated. There are a lot still to do there. Bringing back innovation around partnerships, partnering with the private sector. These are not nice to have. It's not the president who's decided we should do it. It's obligations under UN conventions, under the OECD regulations. We're doing what we need to do, but we're obviously opening up criticism while we're doing that. There are real issues around whistleblower protection and witness protection that must be looked at. There are real issues around the role of the judiciary. There are a number of reforms that need to be looked at, and it shouldn't be too daunting because a lot of this work was already done. I think by the previous Minister Johnny de Lange, a lot of the stuff's already been laid out in terms of what is the reform required in the criminal justice system. What we need now is we need to simplify it down a little bit. We need political leadership to drive those reforms through. But I think we should be careful of piecemeal approaches, and we should be careful of thinking that one change is going to be the panacea. We need to look at it holistically. First panacea is not, the first point to make is the NPA is not the panacea to our corruption problem. We've often said we won't prosecute our way out of this problem. We need to look at the broader reform of the anti-corruption architecture. We need to look at international best practices. So the reform we're speaking about now must happen in the context of that broader reform with the understanding across the country that the rule of law remains precarious. That's the negative side. On the positive side, we must recognize that as a country, we are a mere toddler. As a democracy, our institutions are incredibly young, and they go through these trips and these stumbles over the period of time. In 100 years, we will have institutions comparable to some of the jurisdictions we compare ourselves to. We would have made a lot of mistakes and learned along the way, but our institutions are young. We must focus on building them, but along the way, we must make sure that in trying to build them, we don't make mistakes where we actually undermine them and destroy them.
Quick one, why are prosecutors so fearful?
It's a very difficult environment to prosecute in. When you see your most senior prosecutors being attacked the way they are, being vilified in public, conspiracy theories being swirled around, when you see Section 38's appointed also being vilified in public, we work in a difficult environment. It's hard enough for the NPA that doesn't have a separate salary dispensation like SARS does. We still pay government DPSA rate salaries. You need to keep your prosecutors motivated and protected. It's difficult to do that, but it's even harder to do that when these cases get into the media spotlight and prosecutors get attacked the way they do. And that's not even speaking about the physical risk to prosecutors, which is also extremely, extremely serious.
Thank you very much, Anton.
Just on the one on the DPSA salary issue, because that's an important one, just in terms of us being able to do our work. To give you an example, the SIU has a completely different salary dispensation. We have financial investigators working in the NPA. Within a space of 2 or 3 months, we had 5 of them being employed at the SIU at over 3 times the rate. Over 3 times. And I had to speak to Advocate Motibi about it and say, we can't function like this. So the salary dispensation issue is a huge problem because SARS can hire at a much higher rate. SIU can hire, and FIC, I think, is a similar situation. And we have people from the NPA we train them, we get them to the place where, and then besides the private sector, they are taken by other government institutions at a much higher salary
Mm.
dispensation.
Martin wants to come in quickly, and then I've got questions from online.
Just two quick points. One, Anton alluded to it, that how vulnerable or precarious the rule of law is in South Africa. And I think we know it both in terms of general public opinion. I think a few years ago, Afrobarometer reported that over half of South Africans are willing to give up their vote if they can live in a house and be secure and have a job. And the trust in state institutions is also very low. But we also see it in a more practical way at the prevalence of vigilantism. I think every 10th murder now in South Africa is as a result of mob justice, because people have given up on the criminal justice system. So it's quite serious in that regard. But Anton is right. It's fixing the issues we've spoken about today. Of course, that's very necessary, but it will not be sufficient. The irony is that we know what to do. For 20 years, people have debated these independence issues around the NPA. We keep on repeating ourselves. Draft bills have been written. We even have the draft legislation. It's just a question of getting it promulgated. But of course, and this is one that shouldn't be despondent, but it will require much more than that. We don't know how many crimes are committed in South Africa every year. It's probably around 5 million, according to Stats SA and their surveys. About half of those are recorded by the police. About half of those end up being sent to the NPA for decision. So that's still well over 1 million crimes, many of them really serious compared to many other jurisdictions. And Anton said they have 3,500 prosecutors.
Yeah.
They cannot prosecute all those crimes. It's completely impossible. So one requires a kind of societal renewal, a fixing of other aspects of the criminal justice system to even hope to begin to address these very serious problems.
Thank you very much. Do we have any members of parliament in the house, in the room? I'd love to hear their voices. Please, you're welcome. Ian.
Thank you. No, I actually want to agree with the latter. Recently I had a chat with Anton, and I think at the moment, just from a strategic point of view, the end goal is a bit counterproductive, because from a prosecutorial point of view, you try and empty the court roll and the police tries to fill it. And it becomes a really serious frustration, because I can completely understand that a prosecutor gets a docket, and we so often hear it that the docket was incomplete, or that there were serious discrepancies with regards to how the investigation was done, etc. And then the answer is we won't prosecute. And very often that message is conveyed through a police officer to the public, and the perception is created that they weren't interested in prosecution, which is not the case at all. If the investigation had been done properly, I mean, I'm preaching to the choir now, then it would have been so much more simple. So I think, you know, from a police committee's point of view, we keep on talking about having an integrated or more streamlined kind of approach. And we've heard the same being said specifically from the NPA before, but I still don't hear that from the police's side. It's something that we constantly mention, is that if we don't streamline and have a more integrated approach to tackle some of these things, we're not going to be successful, because the one is completely dependent on the other. We cannot have a situation where there's a siloed approach to any of this. In terms of organized crime and the threats, and I want to add to what Anton said earlier with regards to the risk that prosecutors take, we really mustn't underestimate the physical risk being taken. There is no doubt that assassinations have significantly increased. And I don't say this to be melodramatic towards prosecutors, but we really need to cherish and support as far as we possibly can. And we need to be far more outspoken about investigators / prosecutors being assassinated, and so too whistleblowers. It's almost as though there's this nonchalant thing, oh, it's just another assassination. But it can't become the norm, and I'm fearful that already in South Africa at the moment it's kind of become the norm. We kind of accept it, we condemn it, but at the same time, you know,
becomes normalized.
It's become normalized, and it's a very dangerous place to be. And I must also say, if I can mention assassination in the positive sense, I think it's pushback because I think there are consequences being faced here and there. I mean, what's happening in the underworld around Cape Town at the moment, and the shifts with regards to prosecution of very serious underworld figures that are being prosecuted is a step in the right direction.
Yeah.
And we should acknowledge that.
Thank you very much.
Ferial, may I make a response in
Yes,
relation
and
to
also
those
just a
questions?
final thought I want to, because we start summing up
Okay.
now. How do we ideally protect this fourth branch? What's the role of civil society, the academies in the next 18 months?
Yeah. So I think, if I may, I would just like to speak to our MP Ian and Hans. I think your points kind of align in a sense, right? The threats that prosecutors are under and the need for this kind of cohesive, multi-stakeholder, unsiloed approach. So obviously at the level of policing, to speak to my student, that is administrative action. Many of these guys don't even know the 101s of what that entails. So education and upskilling is majorly important so that there are the fear and the sense of, I can't act because I don't know what is required of me when, is dealt with. And then you're talking about emptying police dockets and court rolls. And this is where I think the IDACs, the law on the IDAC in relation to where there's mention of follow through on what's revealed by commissions of inquiry is really valuable, because their groundwork has been laid. And it's not civil or criminal wrongdoing, but in the legal sense, but it exposes wrongdoing. It's a truth-seeking, fact-finding mission. Evidence is presented, and insofar as the recommendation says, investigate, let's leverage off that. And I actually think that the Zondo Commission model, albeit with some refinement, would be great in alleviating the burden both of the courts that are put often in intractably difficult positions, the police, and then I think we need education, because as our NDPP has said here, obviously they have to give reasons if they're requested to, if they decline to. People should know this. These are like the 101s. So, and I'll tell you what my eldest child said. She once said the one good thing about the lockdown was she got to know her president, because he was on TV every day. Hello, my fellow South Africans. And we need to think creatively about how we can get
Family meetings,
the law
Jamila.
to the people simply and clearly and accessibly, so that these poor policemen and these prosecutors are not fearful and that people are not laboring under incorrect, false impressions. I mean, I've read a book on commissions of inquiry throughout Africa. Do you know how many people will say a commission failed because of the lack of implementation of the recommendations? That's not the commission's fault. That's the state. And we need to relook at that.
Thank you very much. You? Okay. SABC, Abra.
Hi, I'm Abra of the SABC Advocate. I cover Parliament, and I was in the last two Justice committees, and I just got a different vibe there. The first committee was the Zondo Commission access to the database, and that meeting went a little bit sideways from where I was sitting. And then the last committee I covered was when you were doing your annual report. I think it was this week, last week, the end of last week. And the comments were basically from some MPs is that prosecutors need to just pull up their pants and be tough. Do you feel that you have the support of that committee and of Parliament in general when it comes to all of these issues that you have been putting on the
Short answer, which is very sad, because we regard Parliament as a very important, sorry to interrupt you, I'm not sure, a very important instrument of accountability in our constitutional democracy. It's really important. That's why state capture thrived, is because Parliament, the Zondo Commission found that didn't do what it should have done. And so we regard accountability as one of our strategic pillars, hugely important. And so in Parliament, we really want a portfolio committee that seriously holds us to account in respect of, our high level strategies, and understands our challenges and tries to support and guide us in terms of how we can strengthen this incredibly important institution in our democracy, it's the NPA, to be able to do its work better. And we would really want that kind of support and guidance from the committee. We're not seeing it at the moment. Hopefully it'll change. But that's the short answer to that question.
I mean, I think, Ferial,
Thank
that
you.
speaks to your point about the fourth branch. And in fact, the fact that they need to be properly recognized.
Yeah.
You know, because unless we have role recognition of these key players, there won't be respect for what they're doing. And there won't be follow through on what they're doing. And yes, they must be independent, but they must also be accountable, as must all the branches, right? So it's quite simple. Like I think, and it was alluded to earlier regarding the design of the Constitution. Anton raised it, Martin raised it. Certain invisibilities within the Constitution presented problems. And I think we actually need to explicitly state that we have a fourth branch of state, which includes the integrity and accountability branch, and that includes the likes of the NPA.
Thank you.
Then it'll get some respect. Yeah.
I think what Abra is referring to is an axis of state capture, which has moved to
The
Parliament, where
database.
the 4 key people named in the report are actually now MPs, and that throws up questions we haven't even begun to think of properly. But final word to you, I'm coming to you last, Shamila. So Martin, how should the next few months look? So how do you take forward, how do we begin to enshrine these independences? Because everybody has agreed it should be done, but we don't seem to be moving to it because there are so many competing priorities.
Yeah, that's kind of a bit of a vexing question because certainly the independence issues we've spoken about here today, financial independence, operational independence, appointment process for the NPA senior leadership, there seems to be general consensus. The presidency has spoken positively about it. The previous parliament, in fact, many previous parliaments have spoken about it in a very positive way. There is draft legislation which is collecting dust on many desks. There's NDPP's affidavit to the Zondo Commission. So it's vexing why it's not happening. Of course, there are many competing interests, but this is quite an important one, especially given the recent history of state capture. So one would hope, I mean, the previous parliament committed itself, its successor parliament, as it were, the 7th administration, to January 2025, when legislation will be tabled in parliament to bring about this operational independence of the NPA. But that's in 4 months' time, and we haven't really seen any evidence
What's
that
the
that
role
might
of
happen.
civil society in its broadest definition to push this forward?
I think really important. I saw it in Mexico some years ago, where there was a lot of controversy around the independence of the prosecutor. And eventually civil society went to the streets and protested. And that's rare because prosecutors are very hidden away. People don't really think much about what prosecutors do. They get animated about the police and police abuses, judicial independence often very much as well, but prosecutors are quite hidden away in the bigger process. But in that case, civil society really managed to mobilize and start a campaign around prosecutorial independence. And it was partly successful, not completely, but it did animate policymakers to move. And I think to the extent that South Africans can do that as well, and the media, I think, has played an important role and can play an important role, I think those two would be vital to push this over the kind of the finishing line.
Thank you. Final question, Advocate Batoy, thank you for your frankness here today and for sharing with us many insights that I don't think are publicly well known. I want to share one of mine, and also what Irvin Kanyes is asking from online, is I was really surprised the other day to see our Zapiro cartoon. I'm not sure if any of you saw it, but it was of Shamila, I think, is it on the
Sleeping.
ground. Well, and I was surprised by how many of my colleagues were high-fiving that. Like, nothing's happened, there's been no shifts. I guess the effective enshrinement of prosecutorial independence, our topic here today, the flip side of that is some big cases where you land people in jail. I think there've been some big ones. Mike Lomas's extradition is really big. The Gaston Savoy Wataka water tankers case, really big to end that. It's one of our oldest state capture cases. How does your next 18 months look? Because I can't believe that you're going to be that you have 18 months left of your term. Huh?
Yeah, I can't believe it either. But
it's a bit depressing.
yeah, I thought I'll welcome it, but I think because when you do a job that's a purpose in the true sense of the word,
Yeah.
then I think the challenge is it's a blessing in a way, because you want to serve, you want to support, you want to make sure you leave an institution in a very solid foundation, so that moving forward, when we are sitting on our rocking chairs, we can be comfortable and at peace that the NPA is actually, you know, on the right track. And we will never be at peace if we leave this institution feeling that, you know, it's not on solid footing. So there's a lot of work that's been got, very, not the sexy stuff like in court, but institution building. I think maybe the person that drew that cartoon and, you know, didn't realize that it's not only about that one state capture. It's about massive institution building following the devastation of state capture, following COVID, 3.5 years. So there's, I mean, but if you talk about court cases, you know, I've got a whole list of them. It'll take you maybe 5 minutes to go through this. Important cases that are in court already.
Go for it.
And, you know, I mean, firstly, you know, since we've created IDAC, we've had 115 investigations authorized by the investigating director. 37 have resulted in criminal court cases that are being enrolled. 78 matters under investigation. Okay, that's still under investigation. But of the 37 court cases enrolled, 208 accused are before court and 67 entities. There are cases like the ex-MEC Brian Shlongwa, not in the IDAC, but in the SCCU, that was actually withdrawn years ago. It's 1.2 billion scandal involving the extradition of Mr. Payne as well, now from the UK, and on these extraditions, we've had a couple of extraditions successfully, but the media out there will say the NPA is useless because you can't extradite the Guptas, right? Not realizing the UK, we've had Lomas, we've had Payne, we've had Chulota, that are the 3 in state capture. So the NPA knows how to do extraditions, and we've been successful. Dealing with the UAE is another kettle of fish. So we've with regard to SARS collaboration, we've had one of the first recommendations of the Nugent Commission, where a well-known television producer and businessman Ndlovu is now before court in a major case. We've had the Steinhoff matter. We've had Richard Ndluli, the former head of crime intelligence, that's before court. We've had the Speaker of Parliament that's before court. One engineer in one of the PRASA matters, but PRASA is a very important matter, and we are doing a lot to try, but it's very complicated. That matter is an investigation that's in the DPCI. We were working with them, but we realize it's one of those that we really need to get to court, but it's huge challenges. I'm not even going to go into them, but the ex-police commissioner, acting national commissioner is in court. We've had, you know, Mr. Lomas, as you said, has been extradited. I mean, Mr. Pandey from KZN, who was known as untouchable, is now in court fighting for bail. Tonga Hewlett matter, the Transnet transaction advisory matter that's before court, the SAA Express matter in the Northwest, the Estina matter, which we will re-enroll hopefully soon, but one that we're working really hard on as well. Other matters, gang-related matters in the Western Cape, tax matters, I've got details of over 1,800 convictions in the last year, money laundering cases, including to deal with FATF, and gender-based violence, which you talked about. I mean, our Tutuzela care centers are model, international model in terms of, you know, support to victims on their journey to becoming survivors, but I won't deal with that. But asset forfeiture, you know, we've frozen 30.8 billion rands since, and the important thing is since 1999, the amount that we have actually recovered in the past 5 years more than doubles what we've recovered since the asset forfeiture unit was established. And so there's a number of key cases that I can talk to with regard to that. So the point we're trying to make is that it is not, the state capture is hugely important, but it is probably 0.01% of our work, and extremely important that we're focusing on. But if we are judged, even in the media and by some civil society activists that you would hope know better, by the fact that in that space you are not making the progress that the country expects you to, then you're actually putting a very important constitutional entity at risk. particularly now at a time when we are being attacked and you'd find very strange alliances. I mean, in Parliament, there were people quoting a very reputable report that was put out recently. You wouldn't expect them to find that common ground, but they did. And so we are being actually attacked on that basis. So I think it's really important that when, at this point in particular, not for Shamila Batoy, the National Director, or anybody else, but for the office, for the National Prosecuting Authority, for us to realize that this is the new struggle in our country. That right now, if you don't have things like what Martin talked about, maybe people do need to take to the streets because it's the loudest voices are by those that want the NPA not to succeed. And other institutions and other institutions. We need to hear those voices that speak up for these constitutional entities because the fate of our country depends on it moving forward. And so, you know, I want to just maybe one or two more technical aspects in terms of the independence and accountability. They're not mutually exclusive. In fact, I think the more independence you have, the more you should be accountable, the higher the standards of accountability. So the issue of the appointment of a national director, I know the issue, Chapter 9 versus, you know, the current situation. I think the way in which we could strengthen the national director's position is that instead of a simple majority in Parliament, you have a 2/3 majority to remove a national director. That is then what is required for Chapter 9 heads of entities. And I think that would actually help close the gap. In addition, as Martin alluded to, the issue of the operational and financial independence of the NPA. This was very, very sharply raised in the context of parliamentary discussions in the run-up to the IDAC bill being taken through Parliament. And so the previous minister made a commitment that there will be a bill in Parliament of 2025 dealing specifically with the operational and financial independence of the NPA. And I think civil society needs to make some noise about these things. And we really need to, because not for the NPA, but for the country, because it is so important. So we are hoping that this will actually, gain some momentum, because the NPA doesn't draft legislation. It's the Department of Justice. So we can only talk and ask and plead and beg, but at the end of the day, it's out of our hands to get the legislation through. So it's really important that, we have a groundswell of support for institutions like the NPA at this very, very, it's a very different environment we're dealing with in the current, even in Parliament at the moment. And we really need people to identify the challenges. When they say things like the NPA is sleeping, understand what we are sleeping about and tell us, and then we can wake up and deal with that. Otherwise help us, it's a really, really difficult situation.
So there's a long road to independence, but it would be incorrect to say that nothing has happened.
Exactly.
Thank you very much. Cheryl wants to, Cheryl's going to do the thank you.
Thank you.
Thank you. We do have to close this now, but thank you. It's an enormously stimulating discussion. All of you, thank you for putting us into a position to really understand the complexities. I think what it raises, though, for all of us is that it is so complex that we've got to pick these battles very, very carefully, and to do it together and to do it in a very thoughtful way. So I know all of us have our little pet issues that we want to wave around at each other. But at this stage, it's gone beyond the pet issues and the pet peeves. It's now for us to be strategic and careful about how we pick those things. So I want to thank you again, panelists. Thank you so much. And Ferial, once again.
Thank you, sure.
And to just offer you some sustenance for this tough road ahead for all of us. There's lunch on the second floor. So we invite you all to join us.
Thank you.
Thank you very much.
Thank you so much.